Ladies and gentlemen, welcome to this webinar, a practical perspective on the African Continental Free Trade Area. The Trade Law Centre, Tralac, is pleased to be collaborating with Mail and Guardian to bring this webinar to you today. We are also planning a series of follow-up webinars, so we hope you will join us for those as well. Joining me today is my colleague, Professor Gerard Erasmus. Good morning, Gerard, and welcome.
Good morning, Trudy, and good morning to the participants.
Ladies and gentlemen, before we begin, some practical housekeeping matters, and I'll just look at my notes so I don't miss any of those out. We would very much like you to actively participate in the conversation today, and on the right-hand side of your screen, you will see a chat function. You'll be able to post questions and comments, and we'll pick those up and respond to them as we go through the discussion. If we don't have time to discuss all of them, we will answer you later. So that's quite important. We're also bringing you a selection of resources, which you'll see available on the right-hand side of the screen. And this selection includes frequently asked questions on the AfCFTA, which in fact we completed yesterday. So it's hot off the press with the latest information about the AfCFTA. There are also files under the File tab that you will be able to download. So do look out for all the material that is available. This webinar is being recorded, and the link to the YouTube recording will be available for you tomorrow. So without further ado, let's start with our presentation. Ladies and gentlemen, we've indicated that we're taking a practical perspective on the African Continental Free Trade Area. And we're going to answer some very, very relevant and practical questions. What is the AfCFTA? Where are the new opportunities that this agreement holds? And how will it work? Can we trade already under this new agreement? So these are some of the questions that we are going to be looking at. Before we start that, just a couple of minutes to introduce you, if you don't already know, as the Trade Law Centre Tralac. We are a public benefit organization. We're based in South Africa, and we work across the continent on Africa's trade regional integration agenda. And that also includes, of course, issues such as investment, industrial development, competition policy, which increasingly are included in the international trade agenda and feature very prominently in new generation trade agreements. We do research or analysis, and we're a team of lawyers and economists. I'm an economist by training. My colleague, Professor Erasmus, is an international trade lawyer. So a lot of our work has a distinct interdisciplinary approach, and that's particularly important. We do training. Very often these are bespoke training courses. They may be for government departments, regional, continental organizations, and increasingly also for the private sector. So research forms a very important foundation for the training materials that we develop in these bespoke courses. We also facilitate policy dialogue, and this is particularly important to strengthen trade policy processes across the continent. We place a lot of emphasis on improving governance. Governance begins at home at the national level, and it's the quality of governance that we find in the so-called national building blocks, which will, of course, determine what we are able to do with an initiative such as the African Continental Free Trade Area. So what we have here are a few of our new publications, the resources that are available, and we share some of those with you in the facility on the right-hand side. But now let's turn to the business of today. And the first question we look at is, what is the African Continental Free Trade Area? Gerard, I'm going to hand over to you initially for us to discuss this.
Thank you, Trudy. The way that I tend to look at the AfCFTA is to start with the fact that it is anchored in a continent-wide trade agreement. That's the first bullet there on the slide. So since 2015, all the member states of the African Union have been negotiating to conclude a founding agreement and then several protocols for the rules on trade in goods, trade in services, dispute settlement, investment, competition, and intellectual property are in the pipeline, So I would like to emphasize the foundation is a rules-based arrangement anchored in an international agreement with several instruments. We will soon show you the picture, the figure of the various components. The second point is that this arrangement establishes a free trade area, and a free trade area is a standard approach, also recognized under WTO rules, on how trade in goods, originally that was the emphasis, trade in goods must be liberalized by adopting tariff concessions. In other words, the tariffs on goods are to be removed, are to be reduced in terms of schedules, and there will be rules of origin. They have to make sure that only those goods that qualify for the preferential treatment will in fact be traded. Trudy, you can say something about the priority services sectors also covered by this arrangement.
Absolutely. But just to emphasize, of course, ladies and gentlemen, as we indicate here, the minimum requirements for a free trade area in goods are that tariff concessions have been made reciprocally by the negotiating countries and that preferential rules of origin are in place. Now, we know that negotiations on these two essential items are still underway. So that's important to keep in mind. When it comes to services sectors, ladies and gentlemen, services sectors play such an important role in all African economies in terms of their contribution to GDP, to economic activity, employment. But services are also an important trade facilitation matter. For example, goods do not cross borders on their own. We need communication, cross-border payments, transport, and a whole range of services that are essential to effective trade facilitation. So services are increasingly important in all our economies, but we recognize that services are regulatory intensive. So these negotiations tend to be rather complex because domestic regulation effectively means whether you can establish a business in a foreign jurisdiction or whether you can't, whether you can supply services cross-border, for example, financial services or other e-enabled services. The priority services sectors, which we're focusing on the negotiations currently, are financial services, communication, transport, professional services, including legal services and others, and tourism. Now, from that list of services, we recognize, of course, that there are many other services which are particularly important, including, for example, wholesale retail distribution services. And given our experience of the pandemic, healthcare services, education services are increasingly important from a trade perspective. So it is likely that we'll see this agenda also expand. And that would be entirely appropriate in a 21st century digital economy. Gerard, back to you.
Yeah, the final two bullet points just remind us that the AfCFTA has been launched by the African Union, and it is one of several flagship projects of the AU. So there's also what one could call a regional continental integration and a political agenda that are attached to the AfCFTA. It is not a big bang event. The AfCFTA will be implemented over time, progressively. If one reads the founding agreement, that point is repeatedly made, namely that there will be subsequent rounds of further liberalization. And then maybe you want to say something about some of the other flagship projects of the AU and how they relate to the AfCFTA, Trudy.
Thanks very much, Gerard. Ladies and gentlemen, yes, the other flagship projects include, for example, PIDA, and there are a lot of acronyms that we have to reckon with here. This is the Program for Infrastructure Development for Africa. There's also one focusing on industrialization, one on agricultural development. And these, of course, are absolutely linked to the success of the AfCFTA. What African countries arguably really need is to boost their capacity to produce tradable goods and services competitively. And that's where these support programs, the flagship projects, become really important. And they, together with the AfCFTA, form what is known as Agenda 2063. This is really the continental development strategy of the African Union, the continental equivalent, if you like, of a national development plan or strategy. So we recognize that although expectations about the AfCFTA are running really high, the AfCFTA is a free trade area, but it has a second life as a flagship project. And here it finds synergy with other initiatives. And it's in those complementarities and synergies that we can actually address some of the real challenges. Infrastructure, for example. We know that infrastructure, when it comes to transport infrastructure, but increasingly digital infrastructure, are major deficits that have to be addressed. But building roads, lowering fiber cables and so on, while absolutely necessary, is not sufficient. We have to also look at the regulatory issues. So take a look at, for example, harmonization of axle load limits and related transport regulation, because only if we do that will we make sure that we can get access to those infrastructure-related services. And that's another connection with the AfCFTA and its services agenda.
Yeah, truly, this point is very important because the high expectations about what will suddenly happen when this big market of consumers will be one single entity. We must be a little bit sober about that. Only 16% of the goods produced in African countries are destined for other African nations. The AfCFTA is not going to fundamentally change or alter our connections to the multilateral economy. We will have to keep trading with the whole of the world. But if we recall that 16% figure, we will understand how big the gap is and how big the challenge is for boosting intra-African trade. I finally want to emphasize, it is not really only about lowering the tariffs. It is the improvement of trade governance. What happens at borders? These factors are normally lumped together under trade facilitation. But long delays at borders or duplication of documents, those are the governance challenges that will have to be addressed and be focused on in order to make this program work.
I think this point is certainly very, very relevant to this discussion, because we often hear that it is the non-tariff barriers that are the real impediments, and many of them are associated, for example, with regulatory issues, the customs and border management value chain, where time, delays at borders, and the transaction costs that are required to get goods from the farm or the firm, their place of production, to the final consumer or user, can add significantly to costs of trading on the continent, and so erode competitiveness. But these are all also issues, if we do address them in the context of the AfCFTA, ladies and gentlemen, they will have a multiplier effect. Because if we improve the governance of border management, streamline processes, move towards digital trade solutions, then of course, irrespective of who we trade with, there are efficiency gains. So this is where the AfCFTA is also relevant in terms of the overall picture of improving governance. Harriet, would you like to say something about the structure of the legal agreements?
Yeah, thank you, Trudy. At the top of this diagram here, we have the agreement establishing the AfCFTA. That is the so-called umbrella agreement. And then we have protocols. You will see there's a protocol on trade in goods, a protocol on trade in services, and then another green one, the protocol on dispute settlement. They have been negotiated and adopted as part of phase 1. And underneath each and every one of those protocols, there are annexes and appendices. It's a very detailed instrument And the lower we go down into the detail of the annexes and the appendices, the more we will discover the detailed rules, the procedures, and the activities that will have to be launched by the institutions of the AfCFTA in order to make this work. The blue blocks there, they refer to phase 2, and phase 2 will be about negotiations for concluding a protocol on investment, one on competition, and then on intellectual property rights. That is being undertaken right now. These 2 phases are mentioned in the founding agreement, and as Trudy has indicated, that will not be sufficient. We must remember that the plans for adopting this arrangement and for negotiating the instruments, that was launched in 2015, long before COVID. A well-designed agreement like this one cannot be a once-off. So there must be adjustments, there must be advancements and improvements. Phase 3 has been announced, and a protocol on e-commerce has been mentioned to be negotiated as well. Trudy will tell us that there are also other candidates for phase 3 in the pipeline. So what we can take from this particular slide is it is comprehensive. It is a relatively modern arrangement because it doesn't only focus on services, on trade and goods, but also on services. And then if we quickly look at the annexes, there are annexes on so many of the trade-related matters, such as standards, trade remedy, trade facilitation, customs cooperation, and so on. This is a detailed collection of legal instruments. How will it be implemented? It will be implemented and must be implemented by the follow-up action that the state parties must then take domestically in order to give effect to these new rules. Trudy?
Thanks very much. Ladies and gentlemen, just as a reminder, if we look at the annexes to the Protocol on Trade and Services and the annexes to the Protocol on Trade and Goods, the blue items are still under negotiation. So just a reminder, there is still work in progress, even in phase 1. Very important. Ladies and gentlemen, where do we stand? How have we progressed in terms of the negotiations and also, of course, the signature and ratification of the agreement? And on this score, where we stand at the moment is that 36 of the negotiating members of the African Union, they have ratified the agreement. This means that they've completed the domestic processes, usually involves parliamentary approval, and then they've taken the next step, which is to take an instrument of ratification to the depository. And that depository is the chair of the African Union Commission. It's a letter which basically states, we as a sovereign state give our consent to be bound by this agreement. So we are committed, we are now bound by the agreement. Gerrit, I hope that's enough legalese from my side. Ladies and gentlemen, you will see this is the list, the dates on which the various countries have ratified the agreement. Anything to add on that side, Gerrit?
No, I think that's enough, Trudy, simply to re-emphasize the point that an agreement like this is not self-implementing. It has to be implemented through the actions that will now be taken by the various national ministries in the state parties. And maybe we can just remind ourselves that there's a difference between state parties and member states. These 2 terms are defined in the agreement. State parties are those members of the African Union that have ratified this agreement and its annexes. It's one single undertaking, and for whom the agreement has entered into force. The term member states refer to the member states of the African Union. All of them, all 54 of them, Eritrea is absent. All 54 AU member states are participating in the negotiations, but only 36 have become state parties.
Thanks very much, Gerrit. Ladies and gentlemen, this is just the progress that we've made. As Gerrit mentioned, negotiations were launched in 2015 and they proceeded apace, so much so that the agreement establishing the AfCFTA was presented for signature in March 2018 at an extraordinary summit in Kigali, Rwanda, and then started the process of signature and ratification, which progressed so that by the 30th of May 2019, which was 30 days after we had reached the required threshold of ratifications, and that is 22 ratifications had been achieved. And now, of course, the big news in recent months has been the launch of trade in goods on the 1st of January. But the blue box at the bottom, ladies and gentlemen, is just a reminder that there are outstanding negotiations both for trade in goods and trade in services. And then, of course, as Gerrit has mentioned, we're now also negotiating phase 2 and phase 3 issues. Gerrit, over to you.
No, I think this is enough of the technicalities on this one. Yeah. Can you explain to us what the modalities were for the trade in goods negotiations and rules of origin?
Ladies and gentlemen, the modalities for the negotiations, these are really where the negotiations start, where the different member states of the African Union who want to participate in these negotiations decide what will be on the agenda. So it's negotiations about negotiations. And then they agree on the modalities. And this is particularly important because this sets the level of ambition. How ambitious are we going to be, and how are we going to conduct the negotiations? Now, when it comes to trade in goods and tariff liberalization specifically, of course, the agreement reached was that 90% of tariff lines, that's really important, will be liberalized over a period of time. And that period of time for the developing countries is 5 years, for least developed countries, 10 years. Keep in mind, ladies and gentlemen, that 33 of the world's least developed countries are indeed African. And so the diversity and the different levels of development among the member states make this an extremely ambitious, but also very, very difficult process to negotiate. And tariffs are still important for some countries, particularly some least developed countries. This generates fiscal revenue. For other countries, the import tariff is an instrument of industrial policy, because if we raise the tariff, then it means we are increasing the domestic price of a product, and therefore we discourage imports. So very important, the import tariff remains very, very sensitive when it comes to negotiations. So we're aiming to liberalize 90% of the tariff lines. So this, we look at the tariff book and we look at all the different lines, and 90% of them will have to be liberalized. But it's not a big bang approach, as Gerrit has mentioned. It takes place over a period of time. The remaining 10% of tariff lines is to be divided into 2 categories. 7% may be designated sensitive, and we have a longer period of time to reduce the tariffs to 0 for those products. And then 3% of tariff lines, and this is really important, they may be excluded. Now, the term that is used is they are designated sensitive and excluded, which means individual countries will decide that for them, given the criteria which may be used to determine whether a product is sensitive or excluded is used as justification. So a certain agricultural product may be very important for food security reasons, or for national security, or may be a priority on the industrial development agenda of the country. And so it may be designated sensitive or even excluded. And that's really important. So the modalities allow for the expression of national development interests and priorities. But at the same time, they also mean, of course, that they place some limitations on the liberalization that will occur. And what we really have to look at very carefully is which product lines are going to be excluded, because it may well be that among those excluded tariff lines are ones where there is actually potential for intra-Africa trade, where, for example, many African countries do have interests in those industries and sectors. So very important to keep that in mind. Rules of origin, they form a gateway function. They perform a gateway function. They are those criteria which determine the national origin of a product. And so only those products which meet the rules of origin criteria and for which that is certified in a rules of origin certificate will be able to get access to another market in the AfCFTA group at the lower import duties. And the rules of origin, although their function is this gateway keeping function, they can also be used to protect the domestic industry. And this is why these negotiations are always so important to have alongside in tandem with the tariff liberalization negotiations. So we may well see that those products which are designated sensitive, they may have rather restrictive rules of origin. So here we look at the fine print in the agreement. And if we look at the list of products for which the rules of origin are not yet agreed, we'll see some of these product categories where there is distinct interest from many countries who are negotiating the AfCFTA. So they will also appear on the sensitive lists. Clothing, garment products, fish, various other agricultural products, edible oils, and so on. Automotive products, increasingly important for many countries as we've seen investment in automotive assembly, components manufacture in countries from Nigeria, Tunisia, Egypt, Kenya, Rwanda, South Africa, Namibia, Botswana, and many, many others. So if so many countries have an interest, we may find that these negotiations take quite long to come to the necessary compromise, which is the essence of an international trade agreement. Professor Erasmus seems to have disappeared. I hope he'll be able to rejoin us. Ladies and gentlemen, another question that we're asking, where are the new opportunities? What will the AfCFTA add to what already exists in terms of trade agreements and arrangements on the continent? Keep in mind that Africa's trade and integration agenda actually has quite a long history. And so what we have seen over the years is regional economic communities in various subregions, Southern Africa, East, West, North, and Central Africa, have concluded trade agreements. But regional integration also covers many other issues. So in the Southern African region, for example, the Southern African Development Community has a very comprehensive integration agenda. It does include trade, of course. It has a trade protocol and also a trade and services protocol, but it includes protocols on education, on transport, and a range of other issues that are very important for the overall regional integration project. Keeping in mind also, of course, that when we take a look at new opportunities under the AfCFTA, then the question, does the AfCFTA address the real impediments to intra-Africa trade, the non-tariff barriers, trade facilitation, customs and border management, and regulatory issues is particularly important. So let's have a look at that. This is a representation, ladies and gentlemen, of the various regional economic communities that are recognized by the African Union Commission. And that's quite important. There are 8 that are recognized. They are all represented here. And we have right center stage, the Southern African Development Community, but then we have ECOWAS, the Economic Community of West African States, the Arab Maghreb Union, and we go all the way around. But of course, we all know that there are other regional economic communities that exist as well. And for example, the Southern African Customs Union is a very important one. We're mentioning this because the agreement states unequivocally that regional economic communities and their trading regimes will continue to exist. This means, ladies and gentlemen, that the member states of SADC, and in particular the member states of SADC, that are participating in the SADC trade agenda. So they are party to the trade protocol. They will continue to trade with one another under that SADC regime. That's really important. So two issues here. Membership of a regional economic community does not necessarily mean that the country is also a member of the trading arrangement. In the case of SADC, country like Angola, DRC, they are not yet participating in SADC's trading arrangement. So we must make that distinction. It's very important. So the question here then is, who is negotiating with whom? Where are the new market access opportunities going to come through from the AfCFTA? Gerrit, over to you for some comments on that.
Yeah, I lost my connection for a minute. I just wanted to emphasize, Trudy, that the modalities which say that 90% of tariff lines will be liberalized must be correctly understood. It doesn't mean 90% of trade. And the point that you have made, that certain tariff lines may be excluded, can mean that the bulk of trade in goods between certain state parties will or may occur exactly in those excluded tariff lines. So the point, and you've made it, but we have to emphasize, we have to study the fine print. We have to wait till this arrangement is complete, and we will have to look at both the tariff schedules, which will tell us the extent of the reduction of tariffs, in connection with the rules of origin, in order to make a decision or an assessment about the liberalizing effect that will indeed occur. And then I don't know, Treaty, whether you have explained already what was decided to happen on the 1st of January, but we must also tone that expectation down. So if you have already drawn a distinction between the interim trade that was announced on the 5th of December under an incomplete regime, supposedly to start on the 1st of January this year, and the final dispensation, the final regime that will liberalize trade in the comprehensive sense of what is intended in the agreement, we have to distinguish those two phases. I don't know whether you've already explained that.
Thanks very much for adding that, Gerrit. That's extremely important to keep in mind. I am just keeping an eye on the chat room, and this, we have a couple of questions that relate to the modalities as well. So let's have a quick look. Nelson Dirangu. Nelson, good morning, welcome. Would SACU reduce 90% of its tariffs over 10 or 13 years, given that it has an LDC among its membership? Of course, Lesotho is a least developed country. The SACU offer is to reduce tariffs, and we have to go back to the modalities to look at over 5 years, and for the sensitive products over 10 years. So that's quite important to keep in mind. At this stage, the tariff offer that South Africa and SACU have made, and we'll explain a little bit more about this customs union issue, which is very important, covers all of the products for which rules of origin have been agreed. But that's jumping the gun a little bit, so let me come back to that, Gerrit. We'll come back to that in a minute. Liberty is asking, how do we handle the issue of infrastructure? Some countries have very terrible roads, which make it very difficult for movement of goods. I know this forum might not respond to that, but Liberty, you're touching on a very important issue, because unless we address issues such as infrastructure, then concluding a trade agreement, which actually obviously doesn't address that infrastructure deficit, may not achieve the very high expectations that we see for this agreement. And this is why we mentioned the fact that the AfCFTA is also a flagship project, and it finds synergy with, for example, Africa's program for infrastructure development. But that link is so important because it comes through the regulatory agenda as well. So transport regulations are part of the trade and services agenda. So we find another very important connection there. There's a question too, Gerard, let's just have a look about how do we support local industries while making sure not to hinder regional harmony and integration. I think, Tika, for this, what we've got to keep in mind that domestic policy and support initiatives supporting industrialization at home, that continues. There is a national agenda that each of the member states that is negotiating the AfCFTA has at home. They have their particular industrial development priorities. But when it comes to liberalization, we find articulation and expression, if you like, of what our industrial development priorities are through, for example, the products that we designate excluded or sensitive, the ones that we will not liberalize. So again, that industrial development agenda links through to the tariff negotiations and the rules of origin negotiations. But also, equally, it's related to the annexes, which focus on issues like standards, quality assurance. And here again, there are related complementary initiatives underway. The African Bank, Africa's Export-Import Bank, is putting quite a lot of money into the development of quality infrastructure, the testing facilities, all of that value chain which supports the certification, the testing, to assure that we meet the requisite human, animal, and plant health standards, which are increasingly important in a modern 21st century economy. Cham Bama, good morning, Cham, welcome.
Judy, may I just...
Please go ahead. I'll just read this one. Gerard, go ahead. Gerard, please go ahead. Can
Judy?
You unmute? Yes, go ahead.
If I have understood the previous question correctly about a concern regarding domestic industrial activities and development, if all 54 participating nations prioritize their domestic concerns, their domestic development plans, which of course they will do, then it becomes clear that if the intention is to liberalize trade on the continent in order to gain access to new markets, in other words, those new goods that we are going to produce, we want to sell them at the lower tariffs and under the new rules of origin to other consumers in Africa. It means we will have to have a shared plan on how to do that. So it is give and take. It is an indication about how complex these negotiations are. But that challenge must be faced. And we cannot put the emphasis only on our defensive interests, because ultimately then all 54 member states will have only defensive interests. So this challenge is part of the essence what trade negotiations to liberalize trade in goods will really be about and are about.
Thanks very much for that, Gerard. We've got two questions which are particularly relevant to this question of who negotiates with whom. And what we've got to keep in mind is that existing within our regional economic community ecosystem, there are trading arrangements, some of which are free trade areas, but there are also customs unions. And this is very important. But before we take a look at the next slide, which will answer the questions we have in the chat room on these issues, the question is, where are the new opportunities? And if we look from the perspective of SADC in this purple color, these are the member states of SADC. At this stage, these countries, let's say the exporters and importers, because the private sector is, of course, the real trading community. They are trading with counterparts in this gray area on the continent. So importers and exporters located in any one of these other AU member states, they are trading with them under the tariffs and the rules of the World Trade Organization. And for countries which are not yet members of the World Trade Organization. They trade under general rates of duty. Now, this is where the new opportunities for the SADC member states are being opened up. This is where the tariff liberalization is going to take place. So, for example, let's take a practical case. If I'm an exporter, I'm located in Cape Town, and I want to export wine to Nigeria. At the moment, the import duties applicable are the WTO rates of duty of Nigeria. There's scope for tariff concessions to be negotiated there so that that tariff can be lowered. But who will be negotiating with who? And this is where it becomes interesting, because South Africa belongs to a customs union. Now, a customs union is a deeper integration arrangement than a free trade area. And let's just move very quickly to the next slide to have a look at this. This is indeed the SACU group of countries: Botswana, Lesotho, Namibia, Eswatini, and Namibia. Botswana. Thanks, Gerrit. Now, these countries are part of a customs union. It means that they have agreed on a common external tariff. And that basically means, for example, if a T-shirt is coming from India or China or Vietnam, and it's being imported via Walfish Bay into Namibia or into South Africa via Cape Town or straight into Gaborone, it's being flown in by air cargo modality. That import duty is exactly the same. That's a common external tariff. And we have a common customs territory, so no customs barriers, tariff barriers between the member states. Goods can move freely. To protect the common external tariff, we, the members of SACU, negotiate with third parties collectively. So this is why, in Nelson's question a minute ago in the chat room, it's very important. SACU is making a collective tariff offer to these other countries with which it currently trades on MFN, most favored nation, WTO rates of duty. So that's really important. Gerrit, anything to add on that? This is such a critical point.
Yeah, you're quite right, Trudy, and therefore Lesotho hasn't got its own independent trade relationship with the rest of Africa under the AfCFTA. It is part of SACU, and as you rightly point out, the common external tariff applies to all the 5 member states of SACU. And the other point is, before the SACU member states make their joint offer under the AfCFTA tariff schedule and negotiations, they must first talk to each other. They must first negotiate with each other. They must make a joint offer, and they must agree on the joint offer. Lesotho has to agree with the other 4 member states.
Exactly. And when it comes to entry into force and the launch of trade, it is also important that all the member states of that customs union ratify the agreement. Otherwise, we will not be respecting the integrity of the common external tariff and the common customs territory. Now, at this stage, when we looked at that list of which countries have ratified the agreement, Botswana is not yet ratified. So at this stage, the SACU member states cannot yet trade under the arrangement which was launched on the 1st of January this year. And this is then the subject of the next question, ladies and gentlemen. How will the AfCFTA work? Gerrit, over to you on this one.
Let's draw, or let's distinguish between trade under the AfCFTA once all the legal instruments are in place, all the follow-up actions have been taken on or in the various state parties. When this whole arrangement is complete, there will be certainty and predictability as agreed in terms of the rules. And then it's a matter of, as is typical of a free trade area, that goods produced or manufactured in one state party can be exported to another AfCFTA state party under the lower tariffs, provided that the rules of origin are also complied with. That, in essence, is what a free trade area agreement means for liberalizing trade in goods. Trudy will soon tell us how it happens for trade in services. But we are not there yet. This instrument is not complete yet. And why not? Because the tariff schedules and the rules of origin are still to be finalized. They are outstanding. And it's not too difficult to understand why, because they concern the essential, sensitive domestic policies and concerns of member states. So in order to meet the expectations, there was this meeting of the African Union, a special summit in December in Johannesburg, and there it was decided as a type of interim arrangement to start a special regime on the 1st of January this year. And Trudy, can you please explain to us what the basis of that special dispensation was and what your expectations are about what the gains could be?
Thanks very much, Gerrit. This is absolutely critical. You've referred to the political impetus and support for the AfCFTA. And ladies and gentlemen, we haven't seen this level of support at a high political level for Africa's integration for quite a long time. So much so that our heads of state on the 5th of December last year decided that we should launch trade under the AfCFTA for trade in goods on the 1st of January this year. So that decision was made. Given the fact that there are outstanding negotiations on the two essential elements for a free trade area, the tariff negotiations are still underway. They're in a very early stage. And rules of origin negotiations, we've made more progress there, but not in the areas of the sensitive products. They're still ongoing. So what would be the applicable regime? What would be the applicable tariffs? What would be the rules of origin when trade is launched on the 1st of January? And this is what the heads of state decided. They decided that the tariff offers that are made by the negotiating member states, provided that they comply with the modalities. In other words, that 90% of tariff lines are liberalized, and that liberalization takes place over the requisite time period, and that the remaining 10% of tariff lines is divided into sensitive and 3%, 7% sensitive and 3% excluded products. So those conditions would have to be complied with. Furthermore, that within any trade relationship, for trade to be able to start, the principle of reciprocity has to be respected. So for example, I'm sitting in Cape Town and I would like to export T-shirts to Tunisia. I would only be able to trade if Tunisia is also complying with all of the requirements that I've outlined in terms of their tariff offer, that they have met the requirements of the modalities. Otherwise, trade between South Africa, which is part of SACU, the customs union, and Tunisia would not be possible. Furthermore, trade will only be possible for those goods whose rules of origin have been agreed. And that makes absolute sense, ladies and gentlemen. Otherwise, we don't know whether, in fact, those products are of national origin of one of the state parties, because then we could have a situation where goods are coming from a global source and we sew on a button or make some small change and then try to export them under the preferential interim arrangement that is launched on the 1st of January. A third requirement, a very practical one, ladies and gentlemen, is that the countries must be customs ready. And that means that the domestic implementation process has to be in place. And that includes, amongst other things, updating of the tariff book. So include this tariff offer in the tariff book, and we'll show you in a minute what that looks like. That all the customs and border documentation, the rules of origin certificates, the standard certificates, the transit certificates, if applicable, must be applicable and they must be available. The processes must be working so that an exporter such as I, who wants to export to Tunisia, my hypothetical example, would be able to comply with all the customs and border related requirements in order to trade under this interim arrangement. So there are a lot of details in the fine print for this launch of trade under what we're calling an interim arrangement. Indications we have for South Africa are that 2 trading partners have complied both with the reciprocity requirement and the other requirements. And this is noted in a government gazette of the 31st of December last year. They are Sao Tome and Principe, a small island off the West African coast, and Egypt. But in the interim, we've heard that Egypt may be reconsidering its tariff offer. That would mean we wouldn't be able to trade with Egypt. A very important question then is what happens as we continue negotiating, because of course this is an ongoing process. But ladies and gentlemen, this is what I promised to show you. This is what has been gazetted. South Africa has updated its tariff book. Keep in mind, because we're part of a customs union, this is also the tariff book for SACU. So it looks exactly the same for Namibia, Botswana, Lesotho, and Eswatini. And you will note on the right-hand side here, this is the AfCFTA column of tariffs that has been added to reflect the offer that SACU has made. So this would apply to imports coming from those countries with whom we can trade because they have met all the requirements that we've spoken about as of the 1st of January. The bottom line, ladies and gentlemen, is that it is not yet possible to trade under the AfCFTA from a South African and a SACU perspective because Botswana has not yet ratified the agreement. Gerrit, I need your help on the legal issues there.
Yeah, let's start with the practical issues. The practical issues are those that are related to the decision of the 5th of December. If you want to understand or make an analysis, or if a particular firm based in any of the SACU countries wants to investigate and take a decision on the trade potential with the rest of Africa under the interim arrangement, we have to study the fine print. Where do we find the fine print? In that decision of the 5th of December and in the updated tariff book. And there you will see the general rate of duties there, the EU, the EFTA, the SADC, the Mercosur, and the AfCFTA agreements. And by the way, note that if we export through this hypothetical T-shirt to another, let's say to Zambia, because Zambia is a member state of SADC, then there will be no duty, it's free. When we export, when it comes from Zambia, it will be free. If it comes from the EU, it's only 10%. But the column in the AfCFTA is higher. So my response is these decisions, these commercial decisions have to be well informed by studying the legal instruments, because this is what the customs official at the border will implement. Thanks.
Thanks very much, Gerrit. I'm just looking in the chat room and there's a question about how do we deal with imports coming from outside the state parties on the continent. So imports from global sources. Ladies and gentlemen, this is the role of rules of origin. It's a gatekeeper function. So only if the products meet the rules of origin requirements of the AfCFTA, then that product will get access to the lower rate of duty that is being negotiated. And this is so important because
both the parties are state parties.
Exactly. Both must be state parties. But this phenomenon, which we see a lot of, where goods come in to a regional trade arrangement country, for example, and then move to another, that's called transshipment. And that's the role that rules of origin play in a free trade area. So their role is to serve as a way of identifying those originating products that come from one of the state parties and are eligible for the market access, those additional preferences, the benefits that have been negotiated. That's extremely important to keep in mind. Ladies and gentlemen, we have a few minutes left, and we want to refer very briefly to the bigger picture in terms of the overall ongoing negotiations. We've mentioned phase 2 and phase 3 negotiations, and we'd very much like to emphasize the importance of these negotiations. These are issues which are increasingly important in a modern 21st century economy, where digital trade, e-commerce, and a range of very important developments driven by technology, by innovation, are absolutely critical to Africa's development, but also to the national development of all the countries that are negotiating this agreement. The Protocol on Investment, this will cover intra-African investment, cross-border investment among the state parties, extremely important. Competition policy is essential to ensure that anti-competitive or restrictive practices, which in an integrated market space have cross-border effects, that they are countered so that the benefits of liberalization are not eroded by these restrictive practices. So competition policy and regional integration on the continent are really essential partners. Intellectual property rights. Ladies and gentlemen, if I'm investing in a foreign jurisdiction, I need to protect my brand, the trademarks, my industrial designs, to make sure that what I have invested is actually protected. So very important. These link very closely together. And then, of course, there is the protocol on e-commerce. And we've seen during COVID how important digital trade broadly and e-commerce have become. There potential opportunities for smaller scale businesses, for women in trade, for youth, and for other marginalized groups that we've got to have a look at. But I want to pause very quickly and to ask Professor Erasmus to say something about investment and what the protocol on investment could look like for the AfCFTA. It's a topic we at Tralac are putting a lot of emphasis on. It's extremely important because cross-border investment, attracting foreign direct investment, is one of the dynamic benefits that we expect from the AfCFTA. And that's essential for us to diversify, to expand our productive capacity, to create more jobs, more income generating opportunities. But what should be on that agenda? Gerrit, over to you.
Very briefly, because we're pressed for time, the indication in the AfCFTA agreement that is that our Continental Investment Protocol will only be about cooperation. We will therefore see that member states, individual state parties, will retain policy space about attracting investment into their own jurisdictions. We will not see one single institution being established for regulating trade all over the continent. A second observation, and you know more about that, is that the relationship between investment and trade in services under Mode 3, that is commercial presence. Commercial presence of foreign firms, once they're incorporated under the laws of the host country, that is the most important vehicle and pathway for example, trade, investment in trade and services. So unless our protocol on investment is linked to and integrated with what is already in the protocol on trade and service, Mode 3, we maybe see a scaled down instrument. So this is a complicated topic. Maybe we will have to have another session on that one, but I think we must move on to the final ones, Trudy, if there are some left. Yeah, Trudy, here you have listed a number, or we have listed a number of final observations. Participants often ask us, will individual African countries, once they've joined the AfCFTA, still be able to conclude trade agreements with third parties? And the answer is yes. And it's logical and practical and commonsensical to emphasize this point. We are not going to cocoon ourselves on the continent once this agreement is in force. Only 16% of our goods are traded with each other. So trade with the rest of the world must continue. And a free trade area allows the member states, the state parties, to retain policy space over their own tariff rules and tariff regime. There's an important difference between a free trade area and a customs union. The AfCFTA is not a customs union, so there will not be legal impediments or obstacles preventing a country like Kenya, for example, who has already announced that it will negotiate a FTA with the United States and has concluded one with the UK last year. The problem for Kenya may lie in how its other partner states in the East African community will respond to this, because the EAC purports also to be a customs union. And we know that all the building blocks of the common external tariff is not yet in place, but a court case has been launched in the African Economic Community, the East African Economic Community court in Arusha to stop this initiative of Kenya. So to summarize, the AfCFTA is a free trade area. The parties can negotiate with third parties, including states in other parts of the world. However, the really important question here may be, what will the consequences be for your regional economic community that you belong to? And we've already said, and let's repeat it, member states of SACU, because it's a very well-established, more than 100 years old customs union, the member states of SACU cannot individually negotiate trade agreements with third parties. They must do it jointly. Why? Because the integrity of the common external tariff must be protected. And I think that's all, Trudy. You can say something about the rest of the slide.
Thanks very much, Gerrit. The second point is a really important one, ladies and gentlemen. We see significant global interest in the AfCFTA and also from global investors. Keep in mind that if an investor coming from Vietnam, for example, establishes a commercial presence in one of the state parties, it will have access to the benefits of the AfCFTA. So it will then be able to trade under the lower rates of duty that will be negotiated. So this is really important. While we want foreign direct investment, we needed to expand our productive capacity. It will also, if we see foreign investors from global sources coming into the markets, increase competition in our domestic markets. So we have to take a look at that quite carefully. Very important in conclusion, ladies and gentlemen, we see the potential for the governance contribution, the improvement of the African Continental Free Trade Area. And we want to emphasize the trade facilitation function, customs and border management. There are significant new developments in terms of smart borders, cooperation amongst different agencies that are involved in the border management and trade facilitation function. We must take advantage of those new developments, but also governance in new areas such as investment and the broader competition governance area, intellectual property rights. These are the new frontiers in our trade and integration agenda. So we have to make sure that we adopt best practice and develop bespoke agreements that address the particular needs on the African continent, taking into account that the AfCFTA is not a panacea to all the challenges we face, and especially taking into account the impact of COVID. The AfCFTA can play a role and should be particularly important when we take a look at our recovery, reconstruction, and transformation strategies post-COVID. But let's get the negotiations done as expeditiously as we can and make sure that we implement the agreement. Implementation takes place at national level. There's a lot of work that needs to be done, ladies and gentlemen. Let's take a look at the new institutions. We have the AfCFTA Secretariat based in Accra. It's modeled on the World Trade Organization Secretariat. Could it be a new innovative institution that charts a new trajectory for trade and regional integration on the continent? So ladies and gentlemen, with that, we'd like to conclude this. Gerrit, a final comment from you.
Just to say goodbye and hope we can speak to you again.
Ladies and gentlemen, thank you so much for joining us. It's been a great pleasure to have you here. The questions you've asked are really important. We've addressed most of them, but we look forward to seeing you next time. We have our second discussion on the AfCFTA. If there are particular issues you would like us to focus on, please do contact us. Thank you so much. Have a good afternoon.